I'm Josh Escovedo with Weintraub Tobin.
And I'm Scott Hervey with Weintraub Tobin. In a previous episode, we discussed recent applications of the 1950s case Desny versus Wilder, which set the ground rules for idea theft implied in fact contract cases in California. Grasso versus Miramax, another California case, stated that to establish a Desny claim for breach of implied in fact contract, the plaintiff must show that the plaintiff prepared the work, disclosed the work to the offeree for sale, did so under circumstances from which it could be concluded that the offeree voluntarily accepted the disclosure, knowing the conditions on which it was tendered and the reasonable value of the work. A recent non-citable Ninth Circuit opinion on an implied contract case looks at this promise to pay element. We are going to talk about this case on the next installment of the briefing by the IP Law Blog. In California, an idea theft claim is based in large part on the California Supreme Court case of Desny versus Wilder. In Desny, the plaintiff, Victor Desny, wrote a script depicting the real-life story of Floyd Collins, a boy who made headlines after he was trapped in a cave 80 feet underground. In an effort to market his script, Desny called Billy Wilder, a writer, producer, and director at Paramount Pictures. Desny could not get through to Wilder and subsequently stripped his script to the bare facts so that Wilder's secretary could copy it in shorthand over the phone. After reading his synopsis, Desny told Wilder's secretary that Wilder and Paramount could use the script only if they paid him a reasonable amount for doing so. Shortly thereafter, Wilder created his own movie script mirroring Desny's. Because Desny's script was based on historical facts, and because Desny only conveyed the bare minimum of those facts to Wilder's secretary, both parties conceded for the purposes of the appeal that the synopsis was not sufficiently original to form the basis of a federal copyright claim. The court, however, held that Desny stated sufficient facts to establish the existence of an implied in fact contract between the parties. The California Supreme Court explained that where an idea is furnished by one party to another, a contract sometimes may be implied even in the absence of an express promise to pay. A contract exists where the circumstances preceding the attending disclosure, together with the conduct of the offeree acting with knowledge of the circumstances, show a promise to pay.
In the recent case of Ralph Reilly versus Steve Wozniak, Reilly, an IT professor, claimed he had a verbal agreement with Wozniak to create a new high-tech online university based on a course design and outline developed by Reilly. Apparently, at least according to Reilly, the two shook hands on a deal and Reilly developed the course outline. Later, Reilly learned that Wozniak had partnered with Southern Career Institute, Inc. to create WozU. Reilly claimed he went to 2 pitch meetings with Wozniak. Wozniak claimed that he never agreed to compensate Reilly, and further, that he never made any money off of Reilly's idea because Southern Career Institute reached out to Wozniak to license his name and likeness.
In an appeal from the district court's dismissal of Reilly's contract claim, Reilly argued that a party claiming breach of a contract, an implied in fact contract, for conveyance of and use of an idea does not need to show that the claimant offered the idea to the defendant for sale, because California law provides a broad, equitable basis to find implied in fact contracts for the use of ideas. Reilly alleged that it was understood that he and Wozniak would jointly market the concept and that Wozniak would be his partner in exploiting Reilly's idea. The court said that these facts, as alleged by Reilly, do not show an offer for sale, but rather the intent to enter into future business relationships. According to the 1987 Ninth Circuit case of Aliotti versus R. Dankin and Company, no contract may be implied where an idea has been disclosed not to gain compensation for that idea, but for the sole purpose of inducing the defendant to enter a future business relationship. It was in this precise context, the contemplation of a partnership, that Aliotti held that an idea must be disclosed for sale for an implied in fact contract to exist. As such, the Ninth Circuit said that the district court did not err in granting summary judgment because there was no genuine dispute of facts as to whether Reilly offered his idea to Wozniak for sale.
What about the Ninth Circuit's 2011 holding in Mons versus Pilgrim, in which the court said that it sees no meaningful difference between the conditioning of use on payment and conditioning use on the granting of a partnership interest in the proceeds of the production? This ruling seems contrary to that.
The Ninth Circuit did say that in Mons, and I can see how readers of the Ninth Circuit short ruling here could be confused. To understand what the Ninth Circuit was saying in this case, you have to go back to the district court's ruling on the motion for summary judgment. It's there that the district court drilled down on what Reilly was pitching to Wozniak. Reilly wasn't pitching an idea for Wozniak to acquire, as was the situation in Mons versus Pilgrim, where Mons pitched Pilgrim a concept for a show for Pilgrim to potentially acquire and sell to a network. Rather, what Reilly pitched was the concept that Reilly would use Wozniak's name as part of a pitch to potential financiers that Reilly would make for an online computer school. An implied in fact contract requires a reasonable expectation of payment, which can be inferred from the facts and circumstances. The district court found that the evidence established that Reilly initially solicited Wozniak's endorsement to start the Woz Institute of Technology, but not an agreement for payment, not an agreement that Wozniak would acquire Reilly's idea for sale or for partnership, and that Wozniak would be the one trying to exploit that idea. The alleged deal between Wozniak and Reilly, which was strongly contested by Wozniak, happened later. So after Reilly had already disclosed the idea to Wozniak, and two was the reverse of the scenario in Mons and in Desny versus Wilder. As you know, where an agreement to pay, even if it was contested as it is here, if it occurs after the disclosure of the idea, that won't support a Desny claim.
And the court in Desny commented on that specific factual scenario. It said, the idea man who blurts out his idea without having first made his bargain has no one but himself to blame for the loss of his bargaining power. The law will not, in any event, from demands stated subsequent to the unconditioned disclosure of an abstract idea, imply a promise to pay for the idea, for its use, or for its previous disclosure.
The district court found that a reasonable juror could not conclude that Reilly and Wozniak formed an implied in fact contract under Desny because of the fact that Reilly did not seek to sell anything to Wozniak. Now, I think the Ninth Circuit potentially confused the issue with its discussion of Aliotti, when it could have just said that the district court did not err in granting summary judgment because there was no genuine dispute of facts as to whether Reilly offered to sell his idea to Wozniak. I also think that no Desny claim would stand for the reason that if there was in fact a promise to pay, as alleged by Reilly, it happened after Reilly gave his idea, this idea of a Woz branded online technology school, to Wozniak.
It's really interesting, Scott, to see the way that Desny was applied to these particular circumstances, because as you mentioned, there's an obvious difference here. You know, instead of the typical Desny scenario where party A pitches idea to party B then exploits that idea and enters into a transaction. Here we have party A pitching an idea to party B says, sure, party A, why don't you go ahead and run with that? And I'm sure they'll circle back with me later for some sort of partnership. And then party B is subsequently, or, you know, at least that's what's alleged and seemingly proven, is approached by a third party for a similar idea. So it's very interesting to see how Desny is applied here.
Yeah, I mean, Reilly tried to back this into Desny because it wasn't on Woz to take any action to try to exploit this concept. It was on Reilly. Now, look, it might have been different if Reilly had an agreement with Wozniak whereby Wozniak granted Reilly the exclusive rights to pitch and sell this concept with his name. If that were in fact the case, Wozniak would not have been able to enter into this agreement with this third party school, because Reilly would have this blocking right, and they would have to make a deal with Reilly in order for Wozniak to be able to enter into that agreement. But that wasn't the case. This was that's why this is an implied in fact contract case and not a breach of an express contract case. But I think it's an interesting application of Desny and an interesting analysis of Desny, which is why I covered it.
I agree with that, Scott. Thanks for sharing.
Thanks, Joe.
Thanks for tuning into this installment of the briefing by the IP Law Blog. Don't forget to subscribe to our podcast, and for additional content, visit www.theiplawblog.com. Thanks.